Welcome back everybody to Public Law. In this lesson what we're going to be doing is talking a little bit more about different ideas pertaining to the nature, not just of the UK Constitution, but just sort of nature of constitutional theory more generally. And this lesson is going to take a very brief introduction to constitutional theory as a topic. Now, in researching this topic, because I had never particularly taken much of an interest in or even engaged that much in ideas relating to constitutional theory in either my philosophy or law degrees, so I didn't really have that much of an engagement with it. But in researching this particular lesson, just scratching the surface at some of the topics, I'm very much interested, and it's a very, very interesting topic. So I think maybe after we've finished public law, I might do some more research into doing a particular theory, a constitutional theory set of lessons in the future. But for now, this is just going to be an introductory set of points, an introductory video. Just take a brief overview to some of the philosophical and theoretical foundations of constitutional law. Now, this is going to touch on some of the ideas that we've been looking at in jurisprudence as well. We're going to talk about positivism, we're going to talk about natural law, but we're going to talk about it through the lens of constitutional theory and the idea of the Constitution. The idea here is that we have a more foundational theoretical understanding of constitutional theory before we start to look at the framework that exists in the state in which we live, which is, of course, the United Kingdom, and the way in which the UK Constitution operates. It can also be quite useful for when we come back to and redo our lessons on the US Constitution, because, of course, they are very, very different, and different ideas of constitutional law are still bound to the same theoretical principles, some of these theoretical constitutional principles. So, like I said, we're going to be touching on three general approaches to the idea of the Constitution, focusing on one major topic within constitutional theory, this idea of constitutional legitimacy. We'll talk about the positivist interpretation of constitutional legitimacy, we'll talk about the natural law approach to constitutional legitimacy, and then we'll talk about the constitutionalism approach to constitutional legitimacy. The idea here is essentially looking at the ways in which we can understand how a constitution may be justified and the rationale behind the formation and the obligation to follow the rules that are established by a constitution. So this is really one of the most important philosophical questions, this idea about legitimacy. Why is it the case that the Constitution is accepted? And we can apply this specifically to any particular jurisdiction, or we can change one of the words and say, why is it the case that a constitution is accepted? What is it that makes a constitution legitimate? In this sense, we have to essentially ask the question as to what causes people to accept what essentially is the limitation of their power, because that's what a constitution does. It limits the power that the government can exert on the people in certain instances, and it talks about and expresses the specific regulation of the functions of government, of whether that be through checks and balances, whether that be through the separation of powers, whether that be through non-legal sources such as constitutional conventions, as we have in the United Kingdom, whether that be through specific amendments to a codified document like you have with the Bill of Rights in the United States. These are all things that limits the ability for the government to do a particular thing. It limits the ability for the government to become a totalitarian dictatorship, essentially. So what gives the Constitution that legitimacy? Why is it the case that people accept that state of affairs? Now, like I said, this is a set of questions that are far deeper than constitutional theory and can also generally relate to jurisprudential questions about law. Why is it the case that law is accepted within a society? And so as a result of this, we can actually go into the realm of jurisprudence for this lesson, and we can pick out some of the theories that we have within that particular tradition. So we can talk about, for example, natural law and positivism, which is what we're going to do now. We're going to begin with the positivist approach. So a positivist approach may suggest, as we apply this to constitutional theory, that the Constitution is legitimate on the account that we have a wide acceptance of it. So, according to Adler from 2013, for example, we may argue that a constitution is valid or legitimate if enough people whom it concerns, both officials and the public, accept it as to make it broadly effective. This is something of a consequentialist approach to constitutional theory, because it's talking about ultimately the end result of acceptance being important for the fundamental prima facie legitimacy of the system itself. So if enough people accept it, if the sort of end result, the teleology of constitutionalism, constitutional theory, is that we have a broad acceptance of these particular rules, then we can say that it becomes legitimate. So a positivist, and you could also argue even a potentially democratic approach to this idea of constitutional legitimacy, essentially allows an individual to accept that the Constitution is legitimate so long as everybody, or even a majority, or enough people within a society are accepting within its broader framework. They accept that this is the rule and regulation that we are going to follow. It's sort of a legal fiction that we all are obliged to follow as a society. It has to be effective in both the private sense as well as in the public sense. So you have officials, i.e. officials within government, they have to accept it, but it also has to be accepted by the general population, who of course have the ability to exert their democratic rights and their democratic ability to essentially change the government when they choose to, when an election takes place, for example. There may not be any underlying fact of the matter concerning its legitimacy, i.e. it may not be the case that the Constitution is legitimate because of something that is objective outside of the creation and the formation of the Constitution itself. It may just be internally legitimate on the basis of the general public acceptance of it. This is quite an interesting point, because it suggests, therefore, that the legitimacy of a constitution is essentially at the behest of the wills and the whims of the society in which we live. So it could be suggested that it is something of a subjective approach, that if society changes and perspectives within society change, then the constitutional legitimacy of a particular provision, for example, may also change. And we might see some of that when we look at some of the provisions within the United States Constitution, where you have certain provisions, certain amendments to the Constitution that seem to have effective legitimacy when the Constitution was first founded, but then as society has changed and developed over time, we see that it has essentially doesn't necessarily fit in the same kind of way. Of course, some people, including individuals who live in Great Britain, would argue that the US's Second Amendment, the right to bear arms, is something that is particularly strange as a foundational constitutional right, compared that to everywhere else in the world where the right to bear arms does not necessarily exist. And so this could also be seen as something of an argument against a codified state constitution. The idea that if a constitution is so difficult to change that society changes and leaves it behind, and the constitution sort of does not fit the broader mold of society, then this really challenges the positivist approach to legitimacy, that the Constitution may not be legitimate if the entirety of society does not accept it, but if the Constitution is codified and difficult to change, then you might be stuck with a constitution which you do not accept and which may not be legitimate in and of itself. An alternative theory is this idea of natural law. Of course, natural law posits the view that there may be some objective, external, underlying fact of the matter which can legitimize the existence of a constitution. Maybe some kind of objective moral system, an objective morality that legitimizes the existence of a constitution. So many supporters of a natural law theory, for example, may point to this idea of the rule of law, an idea that is fundamental to the UK's constitutional framework, for example, and that this encodes and enshrines very objective standards that exist. We'll get to the rule of law in future lessons' time when we look at the principles of the Constitution. But for the most part, they include things like natural justice, the right of a fair trial, the presumption of innocence, things like that. The idea that that the law is equality, that the law does not discriminate on any kind of basis, on a fundamental basis. Nobody is above the law. All of these different ideas are sort of fundamental to this broader normative framework of the rule of law. Now, on this view, we could argue, therefore, that the legitimacy of a constitution is actually contingent on its conformity to a number of fundamental principles. So rather than the legitimacy of a constitution being subjective on the basis of a societal opinion and a societal acceptance of those rules, it is actually more fundamentally objective. There are some fundamental principles by which, if the Constitution adheres to those principles, then the Constitution is legitimate. So let's say, for example, equality of law, or the rule of law, equality of law, no one is above the law, all these different ideas. These, let's say, are the fundamental objective principles by which the Constitution has to adhere to in order for it to be legitimate. And so ultimately we can then reduce those fundamental principles to the agreed principles of natural law, whatever those principles may be. Of course, people debate as to what the natural law entails. You could maybe argue that the natural law is something of a religious theory still, and argue that the fundamental principles are, for example, the principles within the Bible and the sort of moral natural law that is enshrined by biblical texts. And if the Constitution adheres to that, then therefore it is legitimate. This is something of an objective standard. And so as a result of this, constitutional theory will have a certain degree of moral authority attached to it, given the fact that natural law supports many, or at least many supporters of natural law would suggest that the principles of the natural law are in conformity with the principles of the quote-unquote moral law, an objective sense of morality. The final theory then is this idea of constitutionalism. Now, what constitutionalism is it's a movement not necessarily predicated on a desire to legitimize the existence of the Constitution, but rather it seeks to explain how the government can be legally limited in its power when it is the creator of law itself. So it doesn't necessarily concern itself with the question of what makes a constitution legitimate per se, but asks different questions. It asks the questions of, well, how can a government be legally limited in its power when it is the creator of said law? And it was a movement which came out of political liberalism and in the Enlightenment, the works of, for example, John Locke. And the general thesis of constitutionalism is this idea that the government, while they are the creators of the law, they are limited legally by the existence of this constitution itself. So from this, the authority or legitimacy of government will depend on the observation of this limitation. So we're sort of shifting the lens away from the legitimacy of the Constitution to the legitimacy of government and the extent to which government is legitimate in being able to follow its own limitations, being able to observe the limitations which are enshrined in whatever constitutional framework we're talking about. So, simply put, if the government accepts that they are limited by the Constitution from a legal perspective, then this is where their legitimacy arrives. Finally then, what is the application of constitutional theory? We've been talking quite theoretical so far within these lessons on public law. We've been talking about sort of the nature of a constitution, what a constitution is, and this lesson, of course, has been very much about constitutional theory. What is the application of constitutional theory? How do we then shift now from the theoretical into the more practical and procedural when we start to look at the UK Constitution in more detail? Well, of course, the application of constitutional theory will depend on the type of constitution, given the fact that the US, for example, is a single codified document from which all its authority derives. That therefore means that the US government can be seen as legitimate on account of its adherence to the US Constitution, which is an idea which of course resonates quite heavily with the idea of constitutionalism, and this idea that the government is limited very strongly by the existence of this codified document that is the US Constitution, is of course a very constitutionalism-esque theory. And that makes sense, given the fact that the founding fathers were heavily influenced by the likes of John Locke and the sort of liberal political movement that was coming out of the Enlightenment. It makes sense, therefore, that the US Constitution and ideas behind the US Constitution adhere quite significantly to this idea of constitutionalism. On the other hand, however, we have the UK Constitution, which of course is uncodified and derives from a number of different sources. And so it seems that the legitimacy of the government is an issue which is left more to the people, and the accountability that the people have, and that they can apply to the government itself. It seems that they can create more of an adherence to a positive approach to constitutional legitimacy. And so as a result of this, if we just go here, as a result of this, we find that depending on which constitution we're talking about, will depend on which kind of constitutional theory we can really explore and which constitutional theory really fits that particular framework.